just wasn't argued. It's come up as an argument now, and I went over the pleadings before we started, and I started off the hearing going over those, and I don't recall that being something that's pled, but maybe it has been. I don't know. So I'm going to ask you about that, and I'll give you a chance to tell me about your side in just a minute.
I do not believe it has been pled. It's conceivable that I missed something in the course of the 3 years and didn't remember.
I wasn't looking for it.
I did not remember it,
and so that's the reason I haven't had the chance to go back and read it again. I was just
in the course of the trial was the first time that I had heard it, and I was struck that it was inventive.
You were like me.
I thought it was inventive but wrong.
I haven't really considered it. It just was somewhat of a surprise, and maybe I should consider it. Maybe I shouldn't.
I'm not sure that you should, but if without waiving it, I can say a word or two about it. I'd like.
Let's say something about it, and then I say Mr. Davis has already mentioned it in his argument, and I meant to stop him when he finished and asked about it, but I didn't. I'll give him a chance to respond to it. Okay.
We also pointed out that these folks voted against their interests, which I think, as far as I know, Mr. Davis is correct that the law is not structured in a fashion that draws that distinction, but the presumption, the purpose plainly is to keep you from voting in favor of your own interests.
You know, I worked in the legislature long years ago, and I've seen legislators, not accusing anybody of doing this in this case, but who would vote on the prevailing side when they didn't feel that way, just so they could move to reconsider it, you know. And because they required you had to vote on the prevailing side to make a motion to reconsider. And so I've seen people vote, not their conscience, but for strategic reasons before. I mean, it happens in bodies such as this. So, but anyway, that's just an aside. And that's the reason I think maybe the rule doesn't talk about the vote in favor of your interest or against your interest. I don't know.
Can't see a way here that on Mr. Preston's theory.
I didn't suggest that this was strategic in any manner or fashion at all, but I just said I have seen that happen, and maybe that's the reason for the rule. So sometimes the vote one way can actually appear to be a vote in one direction, and it's actually consistent with the position you were trying to take.
The other thing that we pointed out in the course of our case is that the benefit was not a release of Cindy Wilson and Bob Walker. Now the suggested, and of course I don't think Mr. Hoskins ever mentioned those two.
The lawsuit pending that time was was county against them, but not. Well,
that case was plainly not released by this.
That's what I'm saying. It wasn't Mr. Preston against them. It was the county against them.
Mr. Preston was the named plaintiff, but
in his official capacity, the named plaintiff.
I assume so because Mr. Cunningham eventually ended up.
I've only seen the order in that case, and I don't know whether the prayer for relief in that case included something other than injunctive relief or not. I've only seen the order. That's all that's been presented to me.
I can't answer that.
Okay, go ahead.
At this point. But the benefit of the release actually ran to everybody on county council. And Mr. Davis wants to argue, well, it was really a substantially more benefit to Wilson and Walter, but the benefit was there for all of them. The release is worth something, presumably, and so they all voted on it. They all got it, and that would apply across the board. The other problem with that argument,
if you follow that logic, I'm just talking now.
I got it precisely. It's a reductive ad absurdum.
Is that nobody could vote for a settlement on county council if they were part of the settlement? So
no,
I don't know if that ought to be the law or not. That's an interesting proposition. Go ahead.
But the other problem with the argument, Your Honor, is we think we've proven or provided evidence that Mr. Preston certainly wanted this thing to happen, and he was talking behind the scenes with others. And there was a procedural plan in place to get it through fast. And one of the impacts of that procedural plan was that Ms. Wilson and Mr. Walton did not have time to read this, and it was not primarily about them. And so to the extent that they got caught, if you will, by virtue of the fact that they were handed a document and had to vote on it 15 minutes later, I don't think Mr. Preston ought to be able to benefit by that. Forgive me if I hop around a little bit. But I
brought that one up because it was just somewhat surprising when the issue came up. I hadn't heard it. I thought I'd heard all the issues when we argued the pretrial motions, but there's been a few things popped up.
You had a question from Mr. Davis about fraud, constructive fraud.
Yes, those two causes of action you said you were still pursuing. I just didn't hear him address that in his argument.
And Mr. Davis said he didn't know what we were alleging at all, and so I'd like to explain that.
Yes.
And that is that Mr. Preston was the highest ranking employee of the county. He had fiduciary duty in that capacity. And we have shown, if it needed to be shown, he was aware of Thompson's job search. He was aware of the Palmetto Agricultural Consulting contract. He knew those things. He knew of that conflict of interest, that appearance of impropriety. And he knew both of those things for at least 2 weeks in the case of Palmetto, and longer with regard to Mr. Thompson, before the vote on his severance package. And he said nothing. And we say he had a duty to say something. And that is the failure to speak in the face of the duty to speak that we say supports the breach of fiduciary duty claim, fraud, constructive fraud, negligent misrepresentation. All of those claims arise out of the proposition that Mr. Preston knew the problem with the people voting for his contract, but he was more interested in getting it passed than he was in having it done right. And that, by the way, Your Honor, is the flip side of the continued theme that you've heard from the other side, that, well, the ones who wanted to settle were right because look at how much this has cost the county since. Well, the flip side of that coin, Your Honor, is if this had been done right, if it had been debated properly, if it had been announced, if the public had been allowed to comment, if people who should not have voted, had not indeed led the charge, then it's equally possible that we wouldn't be here today if it had been done right, instead of the impropriety, the amount paid, and the procedural irregularities. So it is the prediction. The Preston side cannot look at what's happened since and say that's all your fault, when they are the ones who didn't do the thing right in the first place. To come back and finish up on the Baird case, Mr. Davis suggested that Mr. Bright's analysis under Cowart had something to do with this. This is a different standard altogether. Mr. Bright was saying this is a government that employment is a governmental function. We're talking about the decision to enter into a severance agreement, and the distinction drawn by those cases is not government versus non-governmental, but whether the body is acting in its full legislative capacity such that it is entitled to particular deference, and only if there are enough bad votes to knock the thing out when you knock it out. In a situation like this one, the courts have likened it more to a judicial type proceeding. They have said just as they would if one member of a 3-judge panel, even if the panel were unanimous, had an undisclosed interest, the whole procedure's out. These cases liken a situation like this one to that. And so the Thompson vote alone, the Wilson vote alone, is enough to invalidate the action in this particular circumstance. And again, we're not asking this court to make very broad law, because I don't know if anything like this is going to happen again anytime soon. It's an extraordinary confluence of particular circumstances, and so there's not a Pandora's box here. This is a truly extraordinary thing. It's not a close case. Mr. Davis invokes the Baird case. He ignores Moody. He ignores Cowart itself, which say you can look at the reasonableness of an act. You can look at public policy. We did not set out to try motives. We don't think that that's. We think that the reason that this is, the court can find this is arbitrary, capricious, unreasonable, is on the face of what happened. There was no anticipatory breach claim. under the contract, Mr. Preston could be terminated at any time. He served at the will of the council. Now, they could have terminated in a way that then triggered the obligation to pay severance, but we never got there. It was simply logically impossible for there to be an anticipatory breach. Could county council perhaps have arranged a buyout at some level that was reasonable? That is possible, but that's not what they did. They paid more. They paid $350,000 more to allow him to retire immediately. And there's no basis for that. There's no justification. And Mr. Davis has tried to say, well, you know, this release is broader, or he's given up so many bits and pieces. But what this case is about the primary provision, the big money. It's not about those kinds of scraps. I'll address the Heather Jones allegations briefly. Again, we proved what we alleged. We proved what we set out to prove. What's significant about that is, again, not the dollar amount that's at issue. It is the surreptitious behavior. It is the willingness to create a false government record and to do it after he was out of office in at least one case. It's part of a pattern that you can see of Mr. Preston's desire to, in effect, exert dead hand control after he left. Fine. The people of Anderson County have voted for people who don't support me. That's great. I'm going to arrange it so that when I leave, I can retire at age 45 forever on a government pension. Michael Cunningham will be put in with a contract like Preston's that gives a similar buyout. Palmetto agricultural consultants will be given a contract that makes it very difficult to fire them. And Heather Jones testified. She said the reason that this was important was insulation against the political change that was coming. The goal of those backdated documents was to insulate, to keep the political change from affecting a friend of Mr. Preston's. And that's not a proper use of time.
Was there any evidence shown, though, that changed anything that wasn't already in effect?
It did not change what was in effect. The concern, though, I suppose, that led them to hide it was that if Mr. Preston had been forthright and said, and put in a memo that said, I agreed to this, I don't see it. Now I'm going to memorialize. I'm going to write in 2008, say that I did it in 2006. Was that might be subject to some political attack? So he created a false document. But no, Your Honor. She had the undisputed evidence is she had to be.
Well, isn't it the standard that breach, for it to be a breach of the contract justifying rescission, it has to be so fundamental as to defeat the purpose of the contract?
It is. And we argue that the fundamental purpose here is that Mr. Preston was supposed to operate in a above-board fashion. He was supposed to leave office at the time that he was supposed to leave office. You heard Mr. Davis argue that Mr. Thompson was qualified and was a good hire. That doesn't have anything to do with whether or not he should have been voting, let alone chairing the meeting. The justification that they offer is a shifting combination of political toxicity generally, of anonymous letters, and of things that were going to happen in the future. And none of those, Your Honor, justifies spending county money to pay. I can see that there's ugliness here in what we've heard. The ugliness, we think, at a minimum ran both ways, but again, I don't think that's the point. I think the point is that the county has to spend its money in a non-arbitrary fashion. And things, certainly there is no compensation due Mr. Preston for things that weren't done by the county. Because the county can't pay for anonymous letters from somebody else. So those things simply have to be off the table. You then heard a lot about the laundry list of items that Mr. Preston submitted in his suit against Ms. Wilson and Mr. Waldron. And in question on direct, he said, yeah, that's everything I could think of. He then shifted a little bit, but I don't know if we've heard of anything else. The point there is Mr. Preston got a remedy. He demonstrated, look, when I have these kinds of political problems, I have a remedy. And he went and he got that remedy. And once that's done, I think those things are off the table in terms of something that the county can justifiably compensate him for. It's admitted that the city and county council did not take any kind of action to breach his contract or to make the kind of clear and irrevocable statement of intent to breach that's required to establish anticipatory breach. Anticipatory breach simply did not exist as a legal matter. What they were saying was, when the new people get in, they're going to do something. And they may well have planned to do something, but even Mr. Greer acknowledged until the hands go up on the vote, nothing has happened. Political promises don't mean a whole lot, and that's for better and for worse on some occasions. When you're actually sitting on county council and you have to make decisions, you may see things a little bit different. Maybe it was not unreasonable for Mr. Preston to say, you know, I've had enough of this, there's a storm coming, I'm going to leave. But the right thing to do in that instance is to hand in your resignation. It is not to engineer a severance agreement under a trumped up, baseless claim, have it presided over by people who are beholden to you, and collect far more than you could collect on your best day in court under your agreement, and certainly far more than would have been negotiated in any kind of an arm's length buyout on the basis of the proposition that there needs to be an amicable divorce. The amicable divorce argument will not support, I don't think it will support a payment at the maximum level of the severance agreement, but it certainly won't support the extra $356,000. And we think for that reason we've proven our case, we've proven all of the elements that we alleged, and the direct verdict motion should be denied.
Thank you. Told you I'd give you a chance to talk on that one point. I'll give you a chance to do that.
I'll be glad to. First of all, Your Honor, with respect to the issue of whether it's pled or not, I'm not really sure what you mean exactly. And the issue of whether they're voting.
Well, I mean, what I was asking him was that I just never had heard that theory or concept advanced until we got into trial, and I was, it was novel to me. It doesn't mean that it's wrong, right, or indifferent. It was just new to me, and I didn't know if it was something that had been kicked around. It was in the pleadings already, and you guys just decided not to argue it. I think you guys are both good lawyers. I'm sure you argue everything you can argue.
Well,
so I'm a little surprised that it came up at this stage of the proceeding. Maybe it was a new idea. Maybe it's something that needs to be played. I haven't looked at the pleadings from that perspective, so I'd like you to comment.
Whenever you prepare a case to go to trial, you start, you know, I remember this, you start putting your hands on every piece of paper and you start assimilating the evidence in a way that you perhaps haven't seen it before. And that's what happened with respect to this case, because I looked down and said, well, there's a financial interest taking the vote of Ron Wilson because his daughter got a contract, or there's a financial interest of McAdoo taking his vote because he got a check 9 months before. And then I started looking at it and I said, wait a minute. October 23rd, 2008. These two people
Cindy Wilson, Bob Walker. Both of them have admitted that they knew that the claims, the tort claims, were directed at them. So that's a little bit of a misnomer. These claims, when he wrote, there's 2 council members. There's no question in this case. Mr. Bright knew it, Bob Waldrop knew it, Cindy Wilson acknowledged it in the deposition, probably not in the stand, but she will. It was her, it was Bob. And the claims were directed at them. They were in the crosshairs, right? And so then they executed or cast a vote in favor of an agreement that provided them a release as to those claims. Well, that was directly in their financial.
Well, it was against it, not in favor of it. She just said in favor of it.
Well, they voted on the agreement.
Well, and one time was an abstention.
And the distinction of voting for or against something, Your Honor, I think your analysis on that is absolutely correct. The problem is that if you have a financial incentive and the vote is, well, you can participate so long as you vote against the measure, Your Honor could sit there and come up with unending numbers of permutations where casting a vote negative to a proposed project could actually enrich the voter in the long run even more, which is the whole purpose behind the prohibition in the first instance. And with respect to whether it's framed by my pleadings, I would suggest to you that it is. I mean, one of my affirmative defenses is specifically under Baird, the Baird doctrine. And that is what I'm saying with respect to this particular vote, that if you say, okay, it's 5 to 1 to 1, and you discount Cindy Wilson and Bob Walter's vote, there goes the 1 to 1, so now you're down to 5 to 0. And let's say you take out the 2 votes that Mr. Gentry stood up and told you to take out. Go down 1, go down 2. Still passes 3-0. That's the point, Your Honor. No matter which way you frame this, no matter which way you turn it, the vote still goes through. Mr. Gentry stood up and he wanted to say that it might be morally obtuse, but it's not factually blind. That's what it's not, because it was very clear that he made every effort he could to run from the facts in actual evidence. And when you look at the facts and the testimony that you've heard from the last 4 days, what you find is that you can call it whatever you want. You can put some fancy label on it, however you'd like. But the facts don't support the legal elements of the claims they've alleged.